So I'm sorry getting started late. I think there was so much going back between the two about when the case was going to be scheduled and trying to make arrangements for it. Ultimately, I thought that we had moved it to the following month. It was actually moved to the following day. And so we're getting started a little late because I kind of pulled things together. I misunderstood what we were trying to do. All right. So tell me, what is currently outstanding, and do we still have the urgency dealing with the assumption, or is that resolved?
Good morning, Your Honor. Esther Panich on behalf of Ms. Knowles. Judge, we are waiting on the recording. So we're not sure that anything is required yet, that everything's completed until it's accepted, because they can always reject the recording for whatever reason. So until then, we don't believe there's anything left to sign at the moment. But again, until the recording is returned, we don't really know. So I know Mr. Knowles has requested the recording to be returned. I am not aware that it has been returned as of yet. So that level of urgency isn't necessary. However, we are here on the 9/15/14, our motion, and Mr. Knowles's motion for reconsideration. The urgency related to the 9/15/14 is that if Your Honor is inclined to grant the motion and the fees that go along with the motion, then Mr. Knowles will actually owe Ms. Knowles money. And my client is concerned about paying him, knowing that he may owe her money and will not have it to pay. So we're hoping that if the court finds 9/15/14 sanctions are appropriate, that the court will order such, and it changes the balance of who will owe who and by how much.
Okay. And Mr. Knowles, your motion for reconsideration deals with what?
Can I add to the initial question of the assumption?
Yes, but first tell me about your reconsideration.
Some new evidence was brought to light, and that the work was not completed in the house. The electrician got back to me, and the handyman also got back to me saying that they provided the quotes, but they were never contracted to do the work.
Your Honor, if I may, the motion for reconsideration is untimely by a lot. It should have been filed by the end of the term of court, which would have been January, as I understand the Stone Mountain Circuit. A new trial would have.
When was the final done? What was the date?
December. Sorry, Judge. I think it's December. It was the end of December of 2023. But I can.
The final order was edited to change the assumption.
No, that's not the final order. That's the emergency compliance. The final order was, I know it was in December. I just need to, maybe my paralegal can look it up while I'm.
It was December
29th, 2023.
Yeah.
And you're saying that, Mr. Knowles, did you say I amended that order?
I thought you did, to include the assumption to change the terms of, like, I thought there was confusion around whose name the mortgage was actually in, if her name was on the deed or not. It was.
But was it amended?
I thought it was, yeah, but I'll have to double check on that. But not yet. I thought it was amended to extend the assumption period and the deed.
Your Honor, that was a contempt. That was separate.
Okay.
The actual order. I don't have any memory of the order itself, the final judgment being amended.
You don't see any amendments to the order right now? Miss Noah, can you pull up that file and see if there are any amendments to the final order that would have been done in December of 2023? Miss Noah?
Can you hear me?
I can hear you. Is she speaking?
She was trying to, but she said there's no amended.
Okay, all right. Something might be wrong. Something that's obviously wrong with the audio. All right, then. So, and when did you file your motion for reconsideration, Mr. Knowles?
30 days after the contempt was issued.
Okay. So I think, unfortunately, it is considered late. It has to be done in the same term of court. So the term of court for December is December. So, excuse me, the term of court it's January, February, March, April, May, June, July, August, September, October, November, December are the same term. So anything that I do in November and December, you have to file before December 31st. And it's that way. Even if I did something on the 30th, you would have to file it December 30 by December 31st, because it's in the term of court.
Okay.
It has to be filed in the term of court. And so if I filed it on December 29th, you still didn't have a couple of days to ask for a motion for reconsideration. Now, you obviously still have the ability you could have had the ability to appeal, but even the appeal is gone now because you only have 30 days after the final to appeal.
Okay.
All right, so now we go to the 9/15/14 motion.
Yes, Your Honor. And Mr. Knowles, we filed our motion in February of 2024. Mr. Knowles filed his response yesterday afternoon. But I think it cut short a lot of our argument because his response seems to concede that petitioner has demonstrated that Mr. Weidman's legal arguments during the October 3rd and 4th hearing lack substantial justification. And there's further on it that says conclusions. I'm not sure what he meant, but it says court findings. Based on the presented information, the court finds that Mr. Weidman's conduct did not constitute a good faith attempt to establish a new theory of law in Georgia based on recognized precedential or persuasive authority. Mr. Weidman's actions unnecessarily expanded the proceedings, and his representation failed to serve the interests of the court, the opposing party, his own client. I think what he's conceding that there's the trial case lacked substantial justification along with these other things that he cites, but he's just trying to shift the blame onto his lawyer. And we would argue we're not asking for Mr. Weidman to be sanctioned. We believe that the fault comes from the client, and the client has the right to, the lawyer can't act without authority from the client. So he seems to concede. I don't know that we have to go through the evidentiary issue of 9/15/14 aside from my showing, but because it seems that he's conceding that there were problems that we shouldn't have had the trial, essentially.
Okay, Mr. Knowles?
Yeah. So I agree with Esther. Going back through the recordings of the trial based off the evidence that I submitted to Bradley in advance of the trial and what he submitted to the court. If that was his strategy, that was a very bad strategy. And I think it was more a lack of preparation, that he didn't prepare for the case. He didn't review the case files. If you remember, I started the case with Cindy Patton, and then got Kimmy Wise, and then got Bradley. So by the time it got to Bradley, after Cindy left the firm, Kimmy got all her cases. And then Kimmy left the firm, so Bradley got all her cases that were doubled up from Cindy. And in my opinion, well, just not in my opinion. So I went to the bar after the trial and met with Mr. Gentry and the COO of the firm. And they, this is in the legal terms, it's not an admission of guilt, but they waived some of the fees from the final hearing for me based off of his performance. His rationale in terms of the poor outcome was that the judge didn't like you. I was like, that's not a reason for you not to submit any of the evidence. Going back to like the daycare versus tuition argument, Chelsea and I had a nanny, and like also I want to apologize for like my demeanor at the final hearing. I went back and watched the recording. I was just frustrated with Bradley and knowing what he had at his disposal versus what he showed up at the final hearing with. I was just
Now, how were you able to watch a recording?
Your Honor had, if I may, Your Honor had, we had prepared an initial draft final order. Your Honor, the law clerk had, or the court's clerk, I don't remember who, redid what the court wanted in the final order and sent us the link to the recording in order to help prepare the final order. So when Mr. Knowles actually filed his motion for reconsideration, he said that there was a marital balance sheet that hadn't been, the wrong marital balance sheet had been presented on his behalf. I went back to the recording and it wasn't true. And so I cited that in my response to the motion for reconsideration. So it's an exhibit in our, it's an exhibit in our, well, it would have been for a motion for reconsideration. So that's where that link.
So even
it was sent to all counsel.
Yeah, with the marital balance sheet, like he asked me, is the accurate picture of the balance sheet at the end of 2022? This case was at the end of 2023, and he admitted as evidence for illustrative purposes, like a year-old balance sheet for the marital estate. It was just from the pre-K nanny thing. We had the pre-K versus tuition, childcare. We had a nanny. Esther, was like, it's not like Mr. Knowles has a religion degree for the religion final decision making. And I do have a religion degree from University of Georgia. My mother has a PhD in education. She's in the leadership for DeKalb County. The school thing, there's pre-K 3 and pre-K 4 in DeKalb County that I've sent Chelsea a list of all the schools, 7 different schools, class openings, which schools to call, videos from police body cam were not available, for you to make your decision. Just a lot of things. And yeah.
Okay. All right. So I need 1 minute, and we come back. I'll start taking I'll listen to you, Ms. Panic, with regard to your evidence.
Thank you, Judge.
All right, everybody, let's go ahead and get started.
Your Honor, may I proceed?
You may.
Okay, thank you. My name is Esther Panich. I'm over the age of 18. I'm an attorney licensed to practice in the state of Georgia since 2006 and in good standing, and in the state of Florida since 1996. I've been practicing elements of family law to include child support, custody, visitation, which are relevant, and domestic violence since 1996. My practice is generally limited to family law and criminal defense, although I have had some personal injury and medical malpractice cases. My hourly rate is currently $5.25 an hour. My client is billed at the prior rate of alternatively $363.75 or $393.75, depending on when in the representation billing occurred. And the discount is provided to her as a benefit of her employment. It's reasonable for an attorney with my level of experience in practice. I have practiced before, Your Honor. Your Honor has previously granted attorneys fees based on my knowledge and experience. So I don't know that I need to go through that anymore. But again, I've been a practicing lawyer for a very long time. I'm also a state legislator, which gives me additional expertise related to the law. My paralegal was billed at $150, and as of January 2024, billed at $200 an hour. Respondent in this case incurred attorney's fees in the amount of $28,115.00
Give me that number
related
again.
to matters of,
Give me that
I'm
number
sorry,
again.
28,115.07 related to matters addressed in my preparation for trial after the petitioner repeatedly refused respondent's offers. The fees were reasonable and necessary. Your Honor, I can go back if the court would like, even though Mr. Knowles has conceded, to just put on the record what the offers were and that they were rejected.
Yes, go ahead.
Okay, the parties appeared for the first part of a temporary hearing on July 29th, 2022. The court entered an order on September 14th, 2022, granting primary physical custody of the minor child and tie-breaking authority on all issues to my client and custody of the respondent's dog, Lady. The parties subsequently appeared on October 11th, 2022, to litigate temporary use and possession of the marital residence. My client prevailed and was awarded temporary exclusive use and possession of the residence because the court determined that the best interest of the child was to return to the marital residence. The court indicated that that is generally her practice. Shortly after the hearing, the guardian ad litem, Rachel Platt, who had conducted an investigation pursuant to her appointment, verbally recommended that respondent have primary physical custody, and mediation occurred on December 29th, 2022, but no agreement was reached. On July 5th, 2023, the parties received a rule nisi, setting a 2-day trial August 7th and 8th of 2023. On July 18th, petitioner, Mr. Knowles' lawyer, sent an offer of settlement, which proposed petitioner be granted recoupment of his purported additional deposit of $22,000 of premarital funds towards the marital home. I asked for evidence. He provided none, which would have made Mr. Knowles' equity greater than 50%, which is not typical of what happens in a divorce case of this type. He also offered that Mr. Knowles should only pay 35% of unsecured debt. The party would share joint physical custody, which went against the recommendation of the guardian, and no child support would be paid by either party. On July 21st, the undersigned by Mr. Weedman and the guardian had a phone call to discuss the resolution of the case. Following the call, I emailed a proposal to resolve the parenting portion by adopting the guardian recommendation, amended to reflect the small changes that the parties agreed to. They had been living with this order and had made minor modifications to suit their interests. I drafted a parenting plan which reflected that exactly. The parenting plan was sent to opposing counsel on July 24th, reflecting that Mr. Knowles would receive 47% of parenting time. Mr. Knowles rejected the proposal, forcing the trial. In pertinent part, the response received from Mr. Knowles was that he would agree to joint physical custody and wanted decision-making in education and religion, which were again not supported by the guardian and were in fact rejected by the guardian. In the final order, Mr. Knowles did not receive joint physical custody or final decision-making authority. As for the equitable division of property, we offered by a letter dated July 17th, a 50-50 split of the equity of the marital residence to the petitioner as they were married at the time of the purchase. And my client had produced evidence that they both equally contributed to the down payment. I never received any proof that Mr. Knowles made any additional payment over 50%. During the litigation, Mr. Knowles committed multiple vexatious acts, many of which he was found to be in willful contempt. For example, refusing to vacate the marital home by 9 a.m. on November 1st as ordered, lying to the court about the location of my client's personal items, which remained in the residence. Mr. Knowles ignored the court and made unsafe renovations to the marital residence. Mr. Knowles refused to provide the login information for the response to pay mortgage. He showed up at my client's dental appointment, believing it was for the child, and then made allegations that the minor child was restrained when in fact she was just in her stroller. He failed to transport the minor child on time. The court noted in the final order, refusing to give Mr. Knowles tie-breaking authority, that he was unable to use proper reasoning. Additionally, at the first trial setting for August 7th and 8th, knowing that my client would be responsible for the pickup of the child, Mr. Knowles tried to convince my client that they were not set for trial, to intentionally send her to the preschool to sabotage her ability to attend the trial by forcing her to go pick up the child. Notwithstanding that, the court continued the final trial date unrelated to that till October 3rd and 4th. We sent again full settlement documents on August 11th, and we received no response. The positions taken, as he has already conceded, the positions taken at trial were lacked substantial justification. They were completely against the guardian's recommendation. They could not reasonably believe that the court would accept these recommendations, that they would accept his position, and that behavior justifies a mandatory award under 915-14A. He has continued to take unreasonable positions that have no basis, and has continued to be in contempt of this court. In fact, but for that, my client has run out of money. He would be again. He has yet to pay any child support ordered under the final judgment or tuition. I think he may have paid $200 once at the very beginning, and he has not paid tuition, which means my client has been responsible for the tuition. Mr. Knowles ended up with 33% of the parenting time, 50% of the equity, and did not prevail in his offer to split the marital funds with 65% in his favor. So we are asking for all of the trial fees that are in the motion for $28,155.07. Fees and expenses to litigate the final issues of the case. I have the bill, and each entry lines up to preparation for trial. We had separated the contempts out of this because Your Honor made separate findings on the contempts. So these are just trial preparation and offers going back and forth, which resulted in nothing. And so we had a trial. There were 2 trial settings for this case, and there were trials for 2 days. The trial took 2 days. I have since, to prepare for today, incurred $3,822.43. Mr. Knowles was constantly warned by this court that if we had to have this hearing, that the court would likely order my fees in order to prepare for this hearing. Those fees turned to $3,822.43. In addition, the court has dismissed or found
3,000, is that in the 28 or is that separate?
I'm sorry, Judge?
The 3,800, is that in the 28 that you're at?
No, that's since the motion was filed with that amount. It's $3,822.43. They're all reasonable and necessary. They were used to prepare for the motion for reconsideration. I'm sorry, Judge, that's the motion for reconsideration. And then the 915-14 was $1,684.38. And we sent those bills this morning, Judge. There were 2 emails. We realized we had a double entry, so we halved the entry because it was difficult to decide which case. I was preparing for both at the same time.
Okay.
So total, if the court is to grant the 915-14 fees plus the preparation fees for both the reconsideration and the 915-14, not including today, which I would need to calculate, would equal $33,621.88, not including today. which would have started at 7 this morning.
Okay, wait a minute. Okay. So you told me 28/115/09.
07, 07.
07. And then you told me 382243.
That's for the motion for reconsideration to prepare for defense.
Okay.
And
And
then,
go ahead.
and the 168438 is to prepare for today's hearing.
168.
438.
Okay. And that totals.
According to my math, my calculator, 33,621.88. And I welcome anybody else who wants to check it.
Okay. All right. Mr. Dawes. You're on mute.
So I went back and looked at the motion for reconsideration, and the motion is for the contempt hearing, not for the final hearing. In relation to the contempt
The
hearing,
motion for consideration is what? For what now?
for the contempt hearing, and not
Okay.
for the final hearing, yes.
The contempt hearing on what?
On child support. But Ms. Panich used that as an opportunity to discuss the assumption and me taking the child out of the state. So we discussed a bunch of issues on that contempt hearing. And this was in relation to the reconsideration that was ruled at that hearing.
Your Honor, the underlying basis of his motion for reconsideration are trial issues related to a marital balance sheet. He's still trying to relitigate the divorce. He's trying to relitigate the divorce in the contempt hearing.
I'm not talking about the marital balance sheet. In the contempt hearing, we heard about
The motion for reconsideration, what date did you file that on?
Give me 1 second. I'm looking it up.
While he's doing that, Natalie, give me a call. All right, so Mr. Knowles, here's what I'm going to do. On the contempt, as I indicated to you previously, I was not as prepared for. I'm prepared because I just know this case generally by the back of my hand, but I did not know we were moving forward with a hearing today, so I don't have the file directly in front of me. I am relying on my staff attorney to send those documents over to me, which she has, and I haven't had a chance to review them in depth. But the summary that I received from staff, my staff attorney, is that your motion for consideration, although filed in the contempt case, is about the final decree. So it was filed in the contempt case, dealing with it when we were handling the contempt, but your issues are appear to be all related to the final, including the marital balance sheet, child support not completing work, all those things that would have been taken, that's not related to the contempt, that would be related to the final. If that is the case, then the court's position is the same. Now, I will actually, when I get into the office, look at the actual document myself and read through it. If I feel like that is incorrect, that there is something that your motion for reconsideration covered on the contempt issue, and that might spark the court doing something different. But for right now, we're going to move forward. My position is that it is out of time because it deals primarily with the final and not with the simple contempt issue. Our contempt issue was dealing with the assumption, and based on the summary that my staff just gave to me, your contempt was not, your motion for reconsideration was not done for the contempt, but done for the final. And so we're going to keep moving forward. Okay.
Can I add something to that?
Yes. Mm-hmm.
So I did an amended motion for reconsideration yesterday. With the amended motion, I added that I did not consent for the fees for the final hearing to be taken out of my equity, and also I'm trying to think what else I added. It was
I don't have a copy of that.
with
I don't
regards
have
to the fees.
I'm sorry, Mr. Knowles.
Yeah,
Ms. Panich is indicating she did not receive a copy of your amended motion for reconsideration. But even so, there's nothing, you got an amended motion for reconsideration that you're filing now, and your motion for reconsideration has nothing to do with your contempt. And now you're saying you want to add some issues related to the contempt the day before the hearing?
yeah. So I got the video of the case 2 days ago, and I just finished like watching it at 4 a.m. this morning.
What video of the hearing?
The two final days, and preparing for this.
Yeah, but that's my point. You're looking at a video of the final hearing to prepare for this hearing, which is related to the contempt. What are you talking about? I'm confused.
Yeah, isn't this hearing the 9-15-14 in relation to the final hearing?
Right, but
Yeah.
you when you came back on, you started by I said, okay, I listened to Ms. Panich, and then I asked you to proceed, and the first thing you said was, I want to go back to my motion for reconsideration. Your position was your motion for reconsideration was timely. That's what it seemed like you were arguing. So I'm then trying to figure out because it seemed to me that you were trying to argue against the court's position that the motion was untimely. So then I wanted you to give me those dates and times so I can kind of figure out what you were arguing. Now you're coming back and saying what? You're not arguing that? Because you need to let me know, because I don't want to waste any more. I don't want to waste time on that because I got staff looking at that issue. But are you conceding it or not?
Yeah, if you can take a look at it when you have the case in front of you, that would be ideal. And we can move on.
Okay, so yeah, that's what I'll do. I'll look at it. If there's something that remains, I'll consider that. But for right now, based on what has been read to me in summary, your motion for reconsideration, although filed in the contempt case, is not about the contempt case. It's about the final. It is out of time. So, but like I said, I'm trying to pull it. I'm trying to log in now to look at it now as we proceed. But I will definitely look at it when I get in another hour. Okay. So let's go ahead and go back to the 9-15-14 issue. You may proceed on that.
Okay. So my position for the 9-15-14 is that Bradley had all the things at his disposal to make a compelling argument, and he failed to do that. I know that Esther and Miss Knowles are not asking for Bradley and Gentry Law Firm to pay the fees, but that's what I'm asking for. In relation, we can start with going back to the nanny versus or childcare versus tuition. My mother is an administrator in DeKalb County and provided me with a list of schools that have pre-K3, so allows 3-year-olds to attend in addition to 4-year-olds. So for the past 2 years,
I'm going to object. None of this is relevant to
Yeah, I'm trying to understand, why is that relevant?
none of this evidence was presented to the court.
Say that again.
None of this evidence was presented to the court.
Your Honor.
No, what evidence?
The list of schools. We're talking about tuition versus childcare. We had a nanny in addition to when.
I get that. I'm not going back to see what was submitted during the course of the case for evidence. What I'm asking you is, for example, when you got offers to resolve your case, did your attorney present those offers to you or not? Were you a part of this process wherein you all were determining whether to go to trial or not? Did you make those decisions?
So going back and forth with the negotiations, I was part of those decisions. The way that it has been presented, the 47% versus the 53%, that was not presented. What I asked for at the final hearing was 6 to 8 days. So that's 42% versus what it currently is, 35%.
I'm sorry.
So I asked for an extra day instead of 9 and 5. I asked for 6 and 8, and that would have been 42 and 58 versus 65 and 35 in terms of the parenting time split, which is less than what was presented by Ms. Banich, and that was not presented to me.
Okay.
Your Honor, if I may, even if that is all true, and I don't accept it, but that's an action against his own lawyer. That doesn't absolve him of any 9/15/14 obligations.
So it's my understanding that for the 9/15/14, it's the party or and / the attorney. So my position is that my attorneys, all three of them throughout this entire case, did not keep a good record and knowledge sharing throughout, from Cindy Patton to Kimmy Wise to Bradley Wyman. Also, going to the final hearing, Esther,
It's Miss Panich.
Ms. Panich, in relation to the guardian ad litem changing her recommendation, the recommendation that we were following between that me and Chelsea worked out. Ms. Panich, when she returned back from, I guess, the Georgia Senate, told Chelsea to stop following that order or go back to the original order of November 2022. In the final video of the hearing, Ms. Platt says that she recommends that, Ms. Knowles only have slightly more time than Mr. Knowles, similar to the 47/53.
I'm sorry. Miss Platt said what?
She has slightly more parenting time. Her exact words were, so because I fully subscribe to that, she has 2 homes, and that's awesome. And that she has 2 good homes, a good home with mom and a good home with dad. But I do think Ms. Knowles should spend slightly more than 50% of her time with Wynn. So I was asking for the 6 and 8 at that final hearing. That was the only issue that was
I don't understand.
pending.
Okay. How much parenting time did you end up getting? 33%?
35.
So if she's saying that Miss Wynn should do slightly more than 50%, isn't that, where is the difference? And slightly more than 50%.
Yeah, is so 6 and 8.
So what we use
is 58/42 split up over 14 days. 9 and 5 is 35/65.
how I don't even, okay, I get it. If I recall correctly, and I don't know when the decision was, I don't know exactly where you were at the time, but my understanding is that you didn't have a place to stay. You did not have a stable place at one point to stay. And then before that, you were in Marietta, and you all were like an hour apart from each other. right? Do I recall correctly?
Yep. Well,
There's no way you all could maintain a 50-50. That just wasn't, that was not happening. And for some reason, I feel as if during the course of this process, that was kind of understood, like that was an impossible position for you all to take, because she would be on the road way too much. And I thought, if I recall correctly, that came out like being a court concern. So I'm not sure exactly, and because I don't have the transcript in front of me either, and I'm not sure 100%, but I do know that the ultimate decision I made was in consideration of stability and where you all lived and where you were. So I'm not sure about what Ms. Platt said specifically, but I do understand, recall being concerned about the distance because there was no set place on your side.
So I'm currently residing.
I'm not concerned about where you currently reside.
And I was always residing with my mother.
With
my mother, we refinished her basement.
Were you not in Marietta at some point or something?
I'm still in Marietta. I'm still in the same place. And I've always been there. Yes.
And so if you go from Marietta to Miss Knowles' home, what was the distance?
I think it's 22 miles.
The time?
This morning, I dropped one off at school at 8:03. We left at 7:23. So about 40 minutes, this morning. And that's downtown Atlanta or Buckhead. And Miss Knowles is a little closer than that. So 35 minutes or so.
Miss Knowles is closer to what?
Closer to Marietta.
Where in Marietta? Because I remember that you all were on the road much longer than 40 minutes.
Yeah, like in the heavy traffic. Yes, going through Atlanta in heavy traffic.
Well, that's kind of what I'm looking at. I don't know. I mean, even morning traffic should be heavy traffic. You might have did 40 this morning because half the people are out on fall break. That's where you might have done 40 minutes this morning. I just can't imagine you doing 40 minutes.
Well, we get to ride the HOV lane because it's two of us.
Oh.
Yeah.
All right. Anyway, you may continue.
All right. So essentially, just with the final hearing, the main thing I was looking to accomplish was more time with her. And what Ms. Spanish had on the table, if that was more time with Wynn, and I presented to Bradley what I was looking to do. And it's one day more, 6 and 8.
When you presented your position to her in July, off the offer of July 8th, what was the child custody split? What do you recall the split being?
So it was 50-50 at that point. We were doing, because the traffic, to your point, is very heavy in the afternoon, and we were supposed to meet at 5:30 in the afternoon every day. So I would just keep her, take her to school the next morning, and pick her up from school. So that's when we were doing the every other day.
We did this 50-50 split. Where were you living at the time I did or said temporarily we're going to do this 50-50 split? Where were you living?
Marietta.
You were living in Marietta at the time?
Yeah, I've always lived in the same place.
I thought at one point you were in the home and Miss Knowles had either stayed with her mom for a little bit or had gotten an apartment. I thought that was the original.
Yeah, sorry. So I misunderstood the question. Before I moved out of the residence, yes, I was in the home. When I moved out of the residence, I immediately went to Marietta.
Yes, but the 50-50, where was that done? When were you in the house at that time?
I was in Marietta.
Okay, so when you were in the house, what was the split at that time?
It was the sober link 4 times a day, supervised visitation. That's when I had my cousin living at the house with me. So when Chelsea dropped off Wynn, there was always someone there. So when I moved out of the house and Chelsea had to drive to Marietta or halfway, that's when the 50-50 was implemented because she didn't want to drive. And so I just dropped one off to school in the morning and picked her up. Like the
So
next,
the 50-50 was what? 1 week on, 1 week off? What was the 50-50?
it was every other day. Instead of meeting Chelsea halfway at the Waverly Hotel in Smyrna, I just dropped one off to school the next morning and picked her up from school. So I did the full transfer to school and back because it was only 5 minutes difference for me driving from Marietta, going to Chamblee versus going to Buckhead. So I didn't mind just taking her the next morning straight to Buckhead.
Okay.
Yeah.
And so the offer at that time was 50-50. And what was the equity in the house offer?
50-50. I think she we were asking for the down payment as premarital funds, but the split of the actual equity was 50-50.
And marital funds?
Yeah, 100% to me.
All right. And then do you recall when in August when Ms. Payne sent an offer to you?
Do I recall what the offer was?
Yes.
The offer, and just reviewing the emails last night, it was she has final decision making on everything. That she had 6 months after she removed my name from the deed to refinance the mortgage. That was our main sticking point. But those were the two big things that stuck out in my brain.
Your Honor, primary respondent.
What about the parenting time?
Parenting time. I don't recall it being 47%, but if Ms. Bannon says it was, then that's more than what I currently got. So that was a better offer. And I wasn't presented the better offer. As I told Bradley, my only goal was to have more time with Wynn. And
so you're saying your only goal was to have more time, or was your goal also you also had some concerns about the marital home? Because I think that seemed to be more of a trigger point than parenting time.
Yeah, so not the marital property, because I have told Chelsea since the beginning I would like her to keep the house. It was
you told Ms. Knowles from the beginning you were vehemently against that. That's not.
So I just wanted her to remove my name from the balloon.
No, that's not true. You absolutely you're forgetting the entire. I remember doing just nothing. You're completely wrong. Your position was that you needed to stay in that house, that your medical condition required you to be able to live in a home that was only 1 story. And you said it was very difficult for you to find someplace else. You were very clear that you needed that home and you did not want her to move in that home. You were not talking about finances. You were not talking about removing your name. You wanted that home as yours. And that became the trigger point. And then at one point I even indicated that I think the whole concept was that I wanted the child back in the home because that was her environment. And you were like, well, she can come back, but I got to be primary because I'm not leaving this home. That was your position. Do you think differently? That was very much your position.
Yeah. So what Chelsea and I discussed and what the legal strategy was, 2 different things.
What?
No, what me and Chelsea discussed privately and what working with Cindy and working with Bradley and working with Kimmy, my goal was to have more time with Wynn. And Kimmy's position was like, if you don't have the house, you won't have more time with Wynn. So, like, my goal was to have more time with Wynn.
So then your goal was to keep the house.
Then yes, if that's more time with Wynn, then yes.
No, I'm not saying if that's, you know what you decided to do. You were fighting for the house, even if your position was because I felt like that was a better way of having more time with her. But I want you to be mindful that you were very much fighting for this house. And I don't want you to think, oh no, that the attorneys were fighting for the house.
No, I take full responsibility.
Because you have to, because that is what you were doing.
Yes, I take full responsibility.
Okay. So, but you're saying that in August, you were not aware that they were offering to give you 47% and then take your name off of the house. Your position, you didn't know that was coming.
No, I did not.
Even though that was the very thing that your position is, you pushed from day one.
To get more time?
Well, you said you pushed from day one, because think about it. At day one, you were at least asking for 50-50. And your position is you wanted Chelsea to have the house. You just wanted your name off of it. They offered you to give you 47%, take your name off the house, and Chelsea would get the house. And that got rejected. But your position is you don't know how that got rejected. Because that's
No.
That's less than what you started out with.
Yes, that's more. Like, it wasn't presented that way. Like, that's what I'm saying. Like, that is a better offer than what I was fighting for. I was just fighting for 42%. They were offering 47%. I was fighting for 42%. Like, that logically doesn't make sense. I was fighting for less time, and my goal was to have more time, and they were offering more time.
Well, that's the whole point of the 9-15-14. The position is that you're doing stuff just because you want to exacerbate the circumstances rather than being reasonable. See, that is what the argument is. Like, your position is, oh, I want to be reasonable. They present reasonable positions in light of your circumstances, and you reject them. And that's the point, because that, in consideration of the, and I can't say 100% that this is what the court always does, but my position is that I want children to be as stable as possible. So, when they have these divorces and the children are still in school and their residency, I want the kids to be in the environment that they're most accustomed to. So it might be that your attorney's position is, well, where the child goes, that's the person who's going to get the house. And then you start fighting over the house more because you recognize that. But the reality is, in the end, the reasonableness is what I'm looking at. Were you reasonable? Could you have come to a resolution that would have been outside of trial, and being reasonable in that regard? And so those are some of the things that I'm looking at as well, just making sure that you're not doing stuff to protract the litigation. And Mr. Knowles, there were certain things that you were doing that just didn't make sense to the court that seemed to be protracting litigation, like arguing things that you had already conceded or indicating that you had already done. For example, the leaving her things outside, and you're saying they're not outside. Like, why would you fight over? And then we come to court and you literally will fight over it when her stuff is outside.
I would love to show you the video. Like, that's one of the things that I'm talking about. Like, there's a video, like Chelsea knows that her stuff, there's a crawl space on the house. That's air conditioned. That's where the containers were. And I'd love to show you the video, because after the case, I was like, Bradley, you made me look like a liar. Like, you didn't show anything.
Okay.
So, and I'm happy to show it right now.
No, I don't want you to be happy to show it right now, because that's done. I've already made a ruling on it. It is what it is. But I was just and that to me is not dealing necessarily 9-15-14. It's just dealing with some of the points that I'm trying to say, is that you'll do these things to make the litigation longer, or you'll take positions that just, they're not reasonable in light of your circumstances. Even like not signing the documents. Like, why are you not signing the documents? I've already told you, Your name is going to come off the documents. Here are the things that we're going to do to get him off the documents. And yet you'll think of something different and won't sign it, And I'm already indicating legally, I'm going to make sure this works out for you. You have the judge who is walking through your divorce circumstances. You can't get any better than that. I'm going to do orders that will protect you to make sure you get what I said you're supposed to get. And it doesn't matter to you. If it doesn't go down the way you want it to go down, you don't do it. And it just protracts litigation. It makes it so much longer, than it needs to be, because you want it done the way you want it done. You can't see it any other way. I don't get it. Like, even dealing with, some of the things you'll bring up about, remember about the key, like where's the door? Oh, she changed the lock, but you haven't even tried the door lock. You haven't even tried the key. Like, you're talking about she changed it. You haven't even tried to get in the house. You haven't even taken your key, go to the door and open the door. But you file motions. Like, it doesn't make sense. You're doing the things that you're doing. I don't understand why you're taking those positions on a lot of stuff.
And that's that's why, with this 914, like in terms of the lawyer or the party, because like with the lock situation, like there's a key lock and there's a deadbolt lock. The deadbolt lock was changed to a code. That's the lock that was changed. So that doesn't even have a key.
Yeah, but you could still get in the house. You just go to the back. You could have gone to the side door with the key, opened the door, and walked in the house. That's it. You'd have been in the house. There would be no issues. She was indicating she wanted to have a deadbolt on the door so that she could give it to the cleaning person, so that that person can open the door with the lock. The deadbolt lock, you could still get in, but that lock would protect Wynn and her, and having other strangers. You should have to leave the door unlocked for the cleaning people. And she explained that to you, and it didn't matter. Like, that to me, that's being reasonable. Oh yeah, I understand, Chelsea. You're trying to make sure that people can come in and clean and do various things and still keep the house safe when you're not there. That's logical. That makes sense. She'll explain that to you, and it doesn't make you'll file motions on it. It's just a lot of little stuff like that. It's those small things that makes me think, okay, when you have a situation when I'm talking about whether you intended to protract litigation or not, makes me think the answer is yes. Even when Ms. Panish indicated before, you were telling me, oh, she went to a dentist appointment and, she didn't tell me. And you literally argued that dentist appointment. You argued that dentist appointment like it was none other. Then at the very end, we learned you knew prior to spending 20 minutes with me on the dentist issue, you already knew that dentist appointment wasn't for Wynn. Like, you knew it before you even argued it, because in the end you asked and they said, no, this appointment is for Chelsea. But you spent 20 minutes of my time arguing that she made a dentist appointment that you knew she hadn't made, because you had found out that appointment wasn't for Chelsea, wasn't for Wynn, it was for Chelsea. Then in the ultimate part of that, it's like you walked in, you found your child strapped to I think you said restraints. And I was like, what kind of restraint was the kid in? Turns out it was her stroller. Why would you say she was strapped to a restraint? She was in a stroller. Those sorts of things that you say make me think you are definitely capable of protracting litigation. And so when you tell me I didn't know that was the offer, it makes me think, yeah, no, probably you did. Because you will say no to stuff to add some strife to your circumstances, and it doesn't make any sense. So when I have to decide credibility wise, whether the lawyer told you and whether you had disregarded it or whether you really would have said yes, I have to also consider all the other decisions you've made throughout the course of this proceeding. And it makes me go, yeah, you probably did know. And you probably said 47, I want 50. And here we are. Because that's not beyond you based on the things that I've seen throughout this litigation. It's like you will do things that don't necessarily, make sense. Like, you're talking about the technical sense of the law, and you're talking about like reasonable stuff. you're right. So the lawyers might be more technical, and you and Chelsea could a little bit be more, common sense about things. If you realize, because you're over the litigation, if you realize it doesn't make any sense for you to be fighting over this house when you know ultimately you want Chelsea to have it, why are you fighting over it? I want Chelsea to have this house, yet you spend 2 years fighting over it. Why? And then you come to me and tell me you don't want to pay her for her fees. You knew from the beginning you wanted her to have the house, yet you fought over the house for 2 years. Explain that to me. What sense does that make? Tell me.
So can I take a step back for a second?
No, just tell me. Tell me why you wanted Chelsea to have the house. You wanted Chelsea to have the house. You
Yes.
wanted was your name off of it.
Mm-hmm.
They tell you that's what they're willing to do. They do an assumption, okay, on the house. But even before then, before we even get to Miss Payne sending you over anything, if you know you want Miss Knowles to have the house, why are you fighting over it?
So in this conversation versus what's an email with Esther, with Victoria, with Chelsea, completely different. Like I offered Chelsea and Victoria and Esther extra time for the assumption to do it right, so we didn't have to go back to court. That's an email. All this is recorded in email. And I'm happy to
Your
share
Honor,
this
this is, I mean, I don't know if the court wants me to respond, but that's the opposite of what happened.
Just allow Mr. Knowles to continue.
Well, it's like I can say a lot of stuff, or I can just show you the photos, like of the Arrow Exterminator, of the Chambly Dental. Like in that situation, I was highly annoyed because the questions that I was being asked could have been answered with a visual picture, letter, like even that I got an exterminator 2 weeks before she was supposed to move in, or in that she saw that her goods were damaged by rodents. Like, but in terms of credibility, like I would rather just show you this stuff or submit it as evidence for illustrative purposes. Like, so if that is going into your thought process for this 9/15/14,
Which one are you talking about?
all of it, just all of them.
No, I'm not. No, I'm not going back through.
I'm not.
I've already found you in contempt of those things. So to me, those not
trying to
really.
erase that.
I'm sorry.
I'm not trying to erase that. Like it's purely from in like a character standpoint, because you have never seen these things, and decisions have been made in absence of seeing these things. So coming to this 9/15/14, it does look like I've just been completely ignoring making rational choices. I would love to show you these exhibits just for illustrative purposes, not to change the contempts that have already been ordered, not to change any fees.
No, I don't have time to. I don't want to look at them for my overall impression of you, so that would change. That doesn't even help you, because those are contempts. They are what they are. I don't need it, because in my field, Mr. Knowles, I'm just dealing strictly with what's in front of me, the law. I don't have any personal animosities against anybody. I'm not trying to determine if you're a good person or bad person. That's for your Lord. Okay, that is not what I'm trying to do. I'm just trying to figure out what the law is and keep it moving. So I don't want you to think that, oh, I like him or don't like him. My staff will tell you, I don't play like that. Like that is not, I'm going to do what's right. Okay. It's not about whether I like you or not like you. It's not about whether I have this idea of who you are. I'm not judging you because that's not my job. That's not my job to judge you, your person. My job is to look at the facts. I'm judging those facts and placing those in the law like they're supposed to be placed. So
100%.
you understand. So it's not, if I saw you on the streets, Mr. Knowles, I'll be like, hello, how you doing?
I think you're very fair. Like, you've been very fair, like with the evidence you presented. Like the decisions you've made, like, have been very fair.
Okay.
Like, I've always said that. And I don't think you are judging me, like, as a person. What I'm saying is that, like, based off of the track record, I just want to set the track record straight as you're going into this decision, because the track record does not look good and it has not been presented well. That's what I'm saying. Like, that's why, I decided, like, I'm not paying, like, Gentry anymore to keep, like, not, like, doing the best thing for, like, that I want, or this case, or even presenting all the facts to you so you can make a sound decision. Like, that's why, like, I'm not, like, I don't got to pay you to lose to pay her. Like, I would rather, like, maybe just was getting a bad luck of the draw with the firm that I went with, because I initially hired Cindy, not Gentry, and then Kimmy going to work for Rachel. I couldn't follow Kimmy because she worked with the guardian ad litem. That was a conflict of interest. Then I was left with Bradley, who was just trying to wrap up the case, didn't put much effort into it. There was a lot of moving parts. So in this hearing, like, coming to this, it's like, yeah, no, I totally agree. The final hearing, based off what was presented, was a total waste of everybody's time. And if, presenting this additional facts are not going to do anything for this, then it's not worth it. So one thing I would ask is that you look at the amendment for the reconsideration. Adding what I added was that what we talked about at the last, I guess, motion to compel or whatever to sign the paperwork, was that the mortgage in itself has a value separate from the house, like that 3% interest rate. And I presented Esther and Victoria with the value of the mortgage outside of the value of the house, because that mortgage doesn't exist for anyone. And Chelsea was not the only person that could assume that mortgage. It was FHA assumed mortgage to anybody. So in addition to selling the house, someone else could assume that mortgage. It's only $1,300 a month for the mortgage payment versus what, $4,300 for the same mortgage. So in using that math, like when we were negotiating, like what the final.
I don't remember having any discussions on the value of the mortgage. We never discussed the value of the mortgage. I thought your position was that you just wanted it out. Your position was you just wanted it out. Well, your latter position was you just wanted it out of your name. I don't think there was any discussion about the value of it. I remember telling you once before that, I think you were saying I think you did mention something like it is going to cost more. It was going to cost her more if she had to get her own mortgage, which would make sense. I mean, she whatever her mortgage, 3%, that's not happening these days. We know that. So, yeah, there is significant savings overall. But I think the whole idea at that time was to remove your name from the list. And I don't think we even discussed, okay, if she were to get another mortgage, it would be an extra percentage. And so you should consider that in the marital debt page. I know we did not do that. In fact, I mean, although it is an interesting point to make, I don't think we dealt with that.
And that's another thing that I brought up with Bradley, like in the final negotiations. And I also sent like Esther and Victoria have that in their motion for contempt, that I came up with all this crazy math. What it is a discounted cash flow valuation of the mortgage over the payment terms. Chelsea is very familiar with this. Chelsea also has an MBA, and we took a financial analysis class together. So just the value of the mortgage in addition to the value of the home, like that being like taken out of, like I was happy with these fees being taken out of that number. So you can see in my motion, amended motion, like the two different balance sheets that I came up with and Esther came up with. And the difference was 177,000. That's, so when I said I did not agree, like to it being taken out of the $83,000, that's what I was saying. I did not consent to that.
Say that one more time.
So the value of the mortgage was $177,000.
And how did you get the 177?
A discounted cash flow analysis.
You gonna have to explain that to me. Whew.
Yeah. So it's taking the interest rate, the 3%, and what the Fed rate was at the time.
Okay, so the rate at the time, let's say it was 5.5. That's
Exactly.
a 2.5% savings.
So I took
Over the life loan.
what the interest rate was that I got, and what at that time that I signed the note, and what the Fed rate was. So what premium did they charge me? The difference between what banks lend to banks and what I got, and then I looked at it as the day of the assumption, what the Fed rate was, and I put that premium on top and calculated the two options. And the savings in between those, equated to like over $1 million. But that's obviously not like what I would expect, because a dollar today is not a dollar tomorrow. So accounting for inflation in 30 years, if someone were to just buy that contract off of me, I would charge them $177,000, because you'd be saving over $1 million over 30 years.
Okay, I got it. I got the general concept of it. Okay, yeah. I think that was more for my back pocket, because I don't think it really has a lot to do with this case, because it was not something that was brought up in the final. So it's nothing nothing that we can do with it. But I do understand your position is you're letting me know the reason why you argued it more vigorously was because you could see the value in it. Okay, I got that part. All right then. Ms. Panich, any final comments?
No, well, aside from the exhibits which support the motion, there are exhibits where Mr. Weidman and I go back and forth on what
you submitted those as well, right? I need to look at those.
Yes, Judge, they're
all right. Yeah, I do apologize, everybody, that I didn't. I got confused. I really did. I thought we were just dealing with one thing, and then I thought that was dealing with the assumption. And then when they said, I think Mr. Knowles may have had going back and forth with my staff about some issues that he had, maybe medical appointments, and then I told him to move it, but I was thinking it was the following month. So I didn't get a chance to go. I didn't get a chance to read through everything, but I will do that when I get to the office in a few minutes and make the final decision at that point. All right. Anything else? No.
No, Judge.
All right. Now we have one more thing, Mr. Knowles. There is Rachel Platt, I think, has an outstanding a bill for guardian ad litem fees. I'm not sure exactly what the rate was that I split for her, but I believe Ms. Marsha told me that she's indicating you owe her some funds. And so we have to have a hearing on that. That might be what we schedule for November. But so that motion, you'll be handling that fairly soon, Ms. Platt, as well. So you'll need to look out for that note. You'll need to look out for that as well, okay?
All right. Yep. I was telling Ms. Marshall, it's like depending on the outcome of this, like I'm happy to just pay that off.
You were happy to do what now?
just pay that off. What the outcome of this?
What was the amount?
$1,400.
Okay, well, you'll look at the note. If anything changes between the two of you talking and you want to move that fine, it won't be until November. I'm sure of that anyway. So you'll have time to talk with her. All right, thank you. Y'all take care. I'll let you know what I'm going to do with this step by the end of the day.
Thank you.
Thank you, Judge.
All right, thanks.